All right, Supreme Court walks out of session. The Honorable Robert J. Torres presiding.
Apede, good morning. You may be seated. Will the clerk please call the case?
This is Supreme Court case number CRA24-008, People of Guam Plaintiff Appellee v. Daniel Clinton Kanata Fejerang, Defendant Appellant. Appearing for Plaintiff Appellee is Attorney Nathan M. Tennyson. Appearing for Defendant Appellant is Attorney Bridget Ann Keith. The panel consists of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, and Associate Justice Catherine A. Merriman. Your Honor, Attorney Keith reserves 10 minutes.
You may proceed, Ms. Keith. It's good to see you back arguing in the court.
Yes, it's nice to be back. Thank you. Chief Justice, and may it please the court. This case comes before the Guam Supreme Court on direct appeal from a guilty verdict at bench trial of a misdemeanor case, and it is a trial that I contend should never have gone forward. The facts are that my client, Mr. Fejerang, punched his victim in the mouth. That was appropriately charged as a misdemeanor. He was never released from custody, and his trial went forward within less than 2 months of arraignment. He waived jury trial on the eve of trial, but the defendant displayed behavior on the day of trial and again at sentencing, indicating that he may not have been competent to be there. The comments are in my brief. He was indicated unsound thinking, and his comments didn't make sense. So the question, why are we here today? It's to answer the question, when this happens, when the defendant shows up and indicates some doubt as to competency, should the court and counsel just go forward? And I contend no. In this case, both the court and counsel have a duty to stop the proceedings. So the issue is, was there ineffective assistance of counsel, first for Mr. Fejerang's lawyer to not raise competency?
Before we get into the issues, has the defendant served his entire 8 months?
He has, in fact, yes.
He has?
He has.
So what remedy can this court provide to the defendant individually?
There are many consequences of a criminal conviction, even a misdemeanor conviction. In Mr. Fejerang's case, this is not his only tangle with the law. Every time that he has a tangle with the law, this conviction will enhance his next sentence. So that's my answer to that. Even a misdemeanor conviction has consequences beyond just the imprisonment.
Before you get to ineffective assistance, I want to address the standard of review, what we should look at here. There's been many federal circuits review a court's decision to not order a competency hearing sua sponte for an abuse of discretion, but other courts look at it in plain error. And you indicated we should look at it for plain error.
I do. I think that's the Ninth Circuit standard, but also, as I was in the case of Dreyer, you'll notice that failure to raise competency by the judge will always only be brought up for the first time on appeal. Because if the defendant's lawyer moved for a competency hearing and the judge denied it, then the reviewing court would review the denial for abuse of discretion. Then there's the standard of review presented by the Attorney General are for when there has already been a finding of competency. He cited the Ibanez and the Titano case. In those cases, they raised competency and they reached competency, and the Attorney General invites this court to review the finding of competency. Well, I contend that's wrong. They should, the only thing you can review is the trial court's failure, and I believe it is clear error because it is brought up for the first time on appeal, and I hope that answers your question.
So just probing a little more, and if assuming that it is a plain error analysis, and the Dreyer court, in terms of its application, seems to suggest that elements 3 and 4, it's more of a structural error if there is a finding. we have the four-part test, substantial rights, and whether or not it affects the integrity of the judicial process.
Okay.
And so does it make any difference? Structural error is very rare if you look at our case law in terms of denial of counsel, and in terms of a open, a closed trial. And so does it make any difference for purposes of our analysis, how we approach that, assuming that the plain error is applicable in this case?
I believe structural error is probably harder to find than plain error, but given that this is a constitutional.
My thinking is the application, and the review of elements 3 and 4, substantial rights. I don't think structural error completely replaces a plain error analysis. I think it's only when you get to elements 3 and 4, do you go through the analysis of substantial rights,
Mhm.
and it's a discretionary review. Whereas structural error, there's no discretion at all. I mean, if it's structural, it's reverse.
I did not argue structural error, and I will explore that because I believe a
It's only because
constitutional.
you raised the case, the Dryer case, and that's when I read it,
Yeah, it's, I mean, it's a very fundamental constitutional right. And so I would contend that it is structural error in addition to plain error, if that answers your question. So the first issue is, can the court even reach ineffective assistance of counsel? And usually that's because all courts like to do it on collateral review, habeas, but in many cases, including this court's Damien case, there was a lot that went on behind the scenes. In this case, there's nothing that went on behind the scenes, and I don't think there's any further record to be developed. So I think this is an appropriate
well,
record.
I don't see it as clearly.
Okay.
I mean, there's a waiver of jury trial, and that is in a criminal proceeding, even a misdemeanor. That is very rarely, I've very rarely seen that in my many years in practice and on the bench. And so I guess when I try to resolve in my mind whether or not the record is sufficiently complete, and if you say no, and that there at an evidentiary hearing would be helpful in reference to trying to find out why was there a waiver of jury trial. Defense counsel is probably going to say, well, attorney-client privilege applies, there's an obstacle for me to provide this information. Well, the holder of the privilege is the defendant. And if there's all these assertions that he's not capable of making rational choices, is he capable of waiving the attorney-client privilege?
Or jury trial.
Well, I mean, you argue that it's possible that defense counsel didn't know of his delusions, or
Right.
that, with him participating by Zoom, no one observed the behavior that would give rise to the insanity defense. And so doesn't that suggest we need to have a better understanding of the record below to make a determination of ineffective assistance?
I think that would make sense, Your Honor, if there were a record below, but we don't really have anything but the.
No, but in a separate habeas proceeding.
In a separate habeas proceeding, you could have him and his lawyer testify. But again, you've got complications with attorney-client privilege. I agree that it's suspicious that he waived a jury trial, and I would have liked to know why. And
Yeah, or why trial counsel didn't raise his mental health as a defense or to the court at that time. I mean, but we don't have enough to be able to help us understand all that. currently.
We don't, but I don't know what more you could do unless you were to remand the case and expand the record. He needed a competency evaluation. And in other cases that have been before this court in the
Well,
Ninth
I
Circuit-
think it's a separate issue. One is ineffective assistance. The other is, whether or not the trial judge should have
Mhm.
order comes to
Separate.
hearing. I think we're discussing whether or not the record is complete enough for us to make a determination of ineffective assistance is where I was at.
Yeah, I mean, I suppose we could. I want to get back to the question of what relief can we provide this person, though? I mean, he's already served the sentence, but this was an opportunity. This young man has, other cases. And every time he comes in front of a judge, he has an opportunity to be evaluated and perhaps assisted. And so I would contend that's why it should, rather than require him to go through a collateral proceeding, which would require him and perhaps his lawyer, who is now gone, to testify. But I think it's more relief to the defendant to just vacate the conviction, send it down for competency proceedings, because that would help him. I think that would help him ultimately more. So, and then if the court can review this record, which I urge that it can, we believe that there is sufficient case law that failing to raise competency when there is doubt is ineffective assistance of counsel under Strickland. I don't think there's any question about that.
What about if the client told him he did not want to raise that issue?
Very good point. There's case law on that. It just doesn't matter. Constitutionally, a person who's incompetent isn't competent to make that decision. And there is law that
Yeah,
that's in
you
my
cited
brief.
the Wisconsin case on that point, the Supreme Court. But my
Yeah.
understanding is that's a minority viewpoint that allows for a narrow and limited breach of the attorney-client privilege when an attorney reports a client's potential incompetency to the court, even against the client's wishes.
But there are other cases where if I might find it in the Ninth Circuit where the defendant has said he didn't want his competency raised, and it's still incompetence, ineffective assistance of counsel.
So is your argument were the red flags such that a reasonable judge should have ordered? Was this apparent during the trial, or is your argument at sentencing, or both?
Both.
I mean, what is
Both,
your
but
thinking?
it was apparent in advance of proceeding with the evidence at trial. So I think the judge could have stopped the case at that point.
And
yes.
what's the basis for your statement that it was apparent?
That his arguments were not making sense and indicated, I believe, that he was delusional. And I think the panel is just going to have to make its own judgment call based on the transcript.
But I mean, a judge also needs to be concerned that, someone is just not trying to game the system. And at such an early stage, is that apparent? However, at sentencing, that might be a little different setting.
It is a different even review at sentencing. Yeah, because he's already been proceeded against. I think at sentencing, Mr. Fejerang's delusions were more pronounced. But I think what I really think this case gives you an opportunity to do is say, when the defendant allocutes in such a way that indicates that he is not tracking, time and place, you must stop the proceedings.
So-
And that's the judge as well as counsel.
So if it was apparent at the time of sentencing,
Yes.
and it wasn't apparent prior to sentencing, how does that affect the verdict?
Well, an incompetent defendant is no more able to be sentenced than he is to be tried. So we're still back at 7.37, which says you must not go forward and you must stop and assess competency. So I don't think it changes the analysis
Yeah, but
much.
I think we're talking about the duty of the trial judge.
Okay.
And it seems to be a continuum of time. If that wasn't apparent during the trial, I'm not saying it was or it wasn't, but if
Okay.
it wasn't, assuming, and he was convicted by a jury, and then, you know, at sentencing with a pre-sentence report and all this additional information regarding his medical condition, I assume that's when that came out, because the record is not really clear to me. And it's apparent to the judge that he's incompetent. Does that affect the conviction when it wasn't apparent during the time of trial? I'm assuming those factual
I
circumstances.
think that if the proceedings were not previously infected with these doubts, that would not affect his conviction. I don't have a basis for ineffective assistance of counsel at the conviction. I believe that it was apparent. And yeah, if he were as clear as day and could testify lucidly, I think the conviction would stand. But I don't think that I don't think he gave any indication that that's what.
But I mean, even putting aside the ineffective assistance, let's say that just as a follow-up to that, at the time of the trial, assuming he was competent to stand trial, there was no evidence to indicate that he was not incompetent to stand trial. But then at the sentencing, after the entry of the guilty verdict by the trial judge, it was a bench trial, that it is determined or was apparent from the record and from the testimony that he was incompetent and should not have been sentenced at that point. So he served his time. The guilty verdict is still there. I mean, you're saying that the guilty verdict will impact his current cases, but what would occur in that situation? Presumably, if there was no evidence of incompetency at the time of the bench trial, his guilty verdict would remain, but he just couldn't be sentenced.
I think I'm compelled to concede that point. If it's a good conviction, I have not argued to overturn that on any other ground but incompetence. But you know, obviously,
And ineffective assistance.
And ineffective assistance. Yes, well, ineffective assistance due to his incompetence. I have not argued to overturn it on any other ground. But I think that this is such a basic right to not be proceeded against if there's doubt. I mean, I'm not asking the court to say he was incompetent, because this court can't do that. That's not what the reviewing court does. I'm just saying that it's such a fundamental right. It's a constitutional right that, but yeah, I agree that if there were a proper conviction, then then the argument would be he wasn't competent to be sentenced. But I think that, I mean, I think the record suggests that the case was, I don't want to criticize it for being rushed, because these competent professionals were really working with dispatch on a misdemeanor case, and they should be applauded for that. But I just think there's such a thing as rushing it too much. And I think that I think this court has an opportunity to say, this is when you put on the brakes. And it's not when he's proven himself to be incompetent, but when he even suggests it, which I think was at the trial.
Ms. Keith, just to get further to your ineffective assistance, it seems to me if there was proper preparation for the trial with the defense attorney, wouldn't that have been brought to the defense attorney's attention earlier?
One would think. And however, that's what I think this case is unique about, is it went so fast that, and we understand the realities of practicing criminal law on Guam. This went fast. There's a lot of cases. I think it was just, it looks to me like it was overlooked. And if it's overlooked, it's ineffective. And so, yeah, we don't presume. I mean, I'm sure Mr. Brown was conscientious in his representation of Mr. Fejerang, but I think Mr. Fejerang just demonstrated at trial that he was not tracking because his comments, I think you just have to take his comments on the record. And even the Attorney General argues that he does, the comments on the record do not meet the high standard of mental disease or defect. He doesn't meet the Dusky standards and all that. But again, this court is not being asked to review whether Mr. Fejerang was competent. It's just, did he present a doubt? And I think the speed of the case speaks for itself. I don't want to say the case was rushed.
It's not clear to me when defense counsel first became aware of, his medical or mental condition that was detailed and exposed in the sentencing
yeah.
report.
Mhm.
And isn't that another reason why we can't make that determination for the first instance, whether counsel was ineffective or not?
I think the reason I would say no is because the defendant himself offered comments, which is unusual for a defendant to start talking to the judge in advance of a bench trial and just start allocuting the way this defendant did. And so that's why my answer is
a lifelong criminal.
I'm sorry, ma'am.
In the sentencing remark, I'm sorry, in the waiver of trial, didn't he say he was a lifetime criminal to the judge?
A lifetime
Criminal,
in the waiver of the jury trial?
yes.
Oh, I didn't, I'll have to look at that. Thank you. I'll look at that and maybe address that, but I know that, yeah, I think we might conclude the trial counsel was just rushing. We might conclude the trial judge was rushing. And again, they should not be criticized for this at all, but I think that this is an opportunity for this court to just say, you have to stop. But I think lifetime criminal doesn't mean incompetent. So I think that we have presented case authority that where the defendant reveals he is not competent, the case authority supports that the proceedings should immediately stop. And I think this is a good opportunity for the court to state that rule. And again, the only other thing I want to add is unless there's any other questions about standard of review, I disagree with the government's statement of standard of review because that is for a finding of competency and there was no finding here. And I disagree with the government's characterization as that he could have been, that there's another way to look at it, that he could have been lucid. It's just all in how you look at it. I think under an objective standard, which is how this court must approach it as an objective standard. I think under an objective standard, the court can say, no, under any standard, these comments, which are captured by the record, indicate that there was possibly a competence problem. Unless there are any other questions, I will submit until rebuttal.
Yeah, you have 7.5 minutes left.
Thank you.
Mr. Tennyson?
Thank you, Chief Justice. May it please the court. The people, in regards to the standard of review, I believe that's a good point regarding the abuse of discretion or the standard for, after a competency has been found, after review of an expert report or something like that. And I think it's fair to say, we would be looking at a clearly erroneous or plain error standard. I think the linchpin of all those issues and reviews is we're looking at the trial court and even counsel's decisions. There is a core of reasonableness in there, and was there a basis for it? And in regards to this case, this is not an easy case. This is You look through the record, it's, I acknowledge all the points that have been raised. It goes very quickly. There's a waiver of jury trial. There's a request for a bench trial. And if we look at the trial itself, there's a time when Mr. Fejerang is talking to the trial court judge and is trying to give some information, and the trial court judge says, well, you've invoked speedy trial. We need to go forward with this. And I think the real issue we have is what we have to work with the record. We have some statements from Mr. Fejerang that are confusing. He's hard to follow sometimes. There are times in there where you can understand what he's speaking of. And really, I think the people's position in looking at this and looking at the elements and trying to balance, because we can't go back in time now. And I mean, even if there's a question of competence, is he competent now? Is he competent for purposes of requesting appeal, of seeking review, of making decisions? We can't go back to the trial itself and determine competency. And as to the competency itself, I agree that if at any point there's a determination that there is an issue with competency, counsel has a duty to raise it. The court has a duty to raise it. We cite to Blackstone in the opening brief, and I think it's a strongly worded, true statement. If at any point someone doesn't have competency, whether it be at arraignment, pleading, sentencing, trial, or even execution, this proceeding needs to be stayed so that they can be evaluated, restored to competency, because they could have spoken in their behalf. And where we're really coming at this from is, was Mr. Fejerang capable of speaking on his behalf? Was he capable of understanding what was going on? Was he capable of working with his counsel to represent his interests? And as we look at the record, we've really broken it into three different sections: plea, trial, sentencing. Those are three disparate events. Those are three disparate times when he needed competency. So according to the records we have, Mr. Fejerang, he invoked speedy trial and he acknowledged that in writing. He waived jury trial, requested bench. He acknowledged it in writing. His counsel was there too. He said, I know, I waive it. I think there is at some level a presumption of competence until we show there isn't. And we don't have anything else from that time in the record we can look at to say whether or not, is it an unusual decision? Is it an uncommon decision? Yes. Could there be?
But isn't it that it's not the issue, whether or not as a result of the actions, there was an implied finding of competency? Isn't the issue is whether or not there are sufficient red flags under 740 that should have alerted defense counsel, the trial judge, that there is an issue of competency here, not whether already there is an implied finding as a result of the actions that occurred in this particular case. And in my mind, the focus is whether or not there were sufficient red flags raised such that the trial judge had a duty under 7.40 to stop the proceeding and inquire into the defendant's competency.
Yes. I believe that's true. The term I would use, and the term I've seen in the cases, many of the cases I've looked through, was it's if one, there's sufficient, something happens, a sufficient element or elements that raise a bona fide suspicion that there could be an issue as to competence. Now, this is when we get to the balancing test that's not easy.
Yeah, especially when you look at the comments that he made about, at trial, about the mother lode of a variety of drugs, flooding the prison with inmates.
Yes.
I'm here to exercise my mind, and you're the only one who can grant that. I mean, it even had nothing to do with the offense that he's before the court.
Yes. And that's, you look at that. I mean, the best, because I need to argue also the opposite standard. He does know what Title IX is. He does know Judge Francis Tydinko Gatewood, and even I can't remember the name of her. I had to write, no disrespect, but I flip her hyphenated name sometimes. So I had to write it down to remember. He remembered that. I think. I could be wrong. But even despite kind of the almost grandeur of the statements he's making, I mean, he has, and it's interesting when I was trying to just interpret what he was saying, he has an even almost sophisticated argument that the criminals on the streets are providing business to the courts and making them use reason in order to fix problems. And this, this does lead to, well, what's going on with Mr. Fejerang? Does that raise a bona fide doubt as to his competency? And that's something I asked the court to look at. I can provide the standard, which is, cases have stated that it's not just one element is sufficient. One element can be if it raises to that level, but we also just can't look merely at the words and the confusion. The other, and as we go down this process, I think the people will also agree that the sentencing is more concerning than the trial. During the trial can still kind of follow. And the other thing we look at when the people were looking at the record is, in other cases, it's more evident that during the proceedings, and this ties into the shortness we have of the transcripts we have. But during the transcripts, there's nothing in the record showing agitation, confusion, lack of understanding, that Mr. Fejerang is getting frustrated, that no one understands him, that his counsel doesn't understand him, that he can't understand the proceedings. There's nothing to indicate that, from what I've seen, that you could reasonably be there and not look at his other actions and say, there's times I have trouble misunderstanding him, but he does seem to, he knows where to go. He knows who the judge is. He knows what is basically going on. Now, does that rise to a level?
Is that really clear that he knows, or?
I think go ahead, sorry.
He answers in the affirmative, without knowing really what,
and that
it is, what transpired.
That's a good question from the record. That's a potential interpretation.
It seems that he said yes to everything.
Yes, and is that a function of he really agreed, or he was just being cordial and accommodating due to some level of incompetence? I don't know. I look at the record. Is there sufficiency in the record for me to say yes, those are just kind of compulsory yeses or empty yeses with no substance?
And was there a proper colloquy between the trial judge and the defendant in terms of his knowing, intelligent waiver of a jury trial?
Insofar as the judge asked and Mr. Fejerang said, yes, I do wish to waive the jury trial. Without, that in itself would be sufficient of someone with competence. And here's the thing: is if we were determined he was incompetent, and this is the problem, is one, we can't determine. So, is there a reasonable, bona fide concern that there was an issue that should have been looked at? Had he been incompetent, he couldn't have. There should have been no proceedings. There's no question. There's no doubt. He couldn't have consented to anything. The question is, did it raise to the point where competency proceedings were required? And even at that point, we go into competency proceedings, it's possible, we don't know what we would see, what would happen. From the record, it's not certain that incompetency would be found. It could be found, but it is speculative. And I think that's when we start to look at, well, what's the remedy? What's the outcome of this? The sentence was 8 months. And my concern with this case is by the time we get to decision, sentence is over. There had been some discussion regarding probation, mental treatment, evaluation, behavioral. So that might be ongoing. I'm not sure. But if it becomes an issue of he should have had competency proceedings, I think we would be looking at reversal back to whenever the last point. I suppose you'd be looking at the point where there was a bona fide, there's a determination of bona fide factor existed requiring a competency evaluation.
Is there any then, having raised that, at what point? Is there any significance that during the pretrial proceedings, the trial judge said, you may want to consider a plea agreement, or suggested to both the defense counsel and the attorney general? Is there any significance in that statement?
Significance, could you?
In reference to whether or not the trial judge had any inkling or hesitancy regarding, number one, the competency of the defendant, whether you understood what was going on. Because you're seeming to suggest that there, which, is what the case law is, at what point was it apparent to the trial judge that the defendant probably, does not understand the nature of the proceedings? Was it at the time of sentencing? Was it during pre-trial? Was it apparent before he made his decision to convict him on the record? I
think so. For that question, and I would best preface this by saying when I look at the record and the people's position is, the judge looks at everything, the defendant counsel looks at everything. I think with the totality of circumstances, there is a reasonable determination to be made. But as to the question of when would that have arisen in the judge, I think the judge would have first been aware of it after the discussion you referenced, when Mr. Fejerang provides his kind of soliloquy, and I believe in the transcript, it looks like the trial court judge kind of abruptly wants to move on and kind of stop Mr. Fejerang from continuing in, I think, a fairly unstandard opening statement at trial. And then the proceedings go forward from there. And even we have the second issue at sentencing, where it's a similar situation, but Mr. Fejerang is a little, even more so, difficult to follow and understand. I would say the first inkling, if there was an inkling to be had, would have been at the trial initially, when the waiver discussion was going on. Do you want to settle? Do you want to continue on to trial? This is kind of your last chance before we proceed. And then, beyond that, the people would just kind of been using competency, mental illness. I don't think we've said mental defects, but the terms aren't interchangeable. Mr. Fejerang does have a history of mental concerns. He does have a history of bipolar disorder. He does have a history of substance abuse, alcohol abuse. Those are all referenced in his pre-sentencing report. Defense counsel was aware of his condition. When did trial counsel become aware? I can't tell from the record. But when I look at the record, what I see is defense counsel possibly making a determination of, my client has bipolar, he has substance abuse. Some of these communication issues, delusion issues might be the result of drugs or alcohol. And having to make this assessment of, well, is he competent? And that's going to be subject to trial counsel's interactions with Mr. Fejerang. I don't know how much they spoke with him. From the record, there's little interaction, but there could have been discussions, there could have been meetings. And there could have been times when Mr. Fejerang was able to accomplish some communication with his counsel. We can't tell. And my default is to fall back to presuming that the trial court and defense counsel were acting reasonably, that they took multiple factors into consideration, more than we can see now, because we just have the transcripts and the words. We can't see the actions and how things were operating. Now, is that enough to compensate for the spoken words? That's something the court needs to determine. That's something the court needs to look at in light of the substance and context, the procedural history. Because while Mr. Fejerang would note a lot of the things are unusual, there can be reasonable basis for them, and they're not automatically indicators. So, like asking for a speedy trial, or waiving jury trial, as unusual as that is, I would not take as an element of incompetence. Now, if that decision was made while incompetent, it can have no force or effect. How can it? But a competent person could do that. And without knowing the reasons for why, it's difficult to make a determination as to the soundness of the decision. It could have been done because trial by jury would take longer. Maybe he thought he had a better chance with the judge rather than a jury. Maybe he just wanted to talk to the judge. I don't know. And that would lead into incompetency questions. But for
That
example,
alone doesn't really trouble me. I mean, I can understand, and I think, obviously we're missing something in terms of that decision and what made that. But
and
it's the other things that happen when he interacts with the judge that are a little more troubling.
and I also find those troubling. The position the people need to view it from is, does it raise a question as to competency? Does it raise a bona fide question that the trial court had a sua sponte obligation, due process obligation to order a competency exam? And my only personal experience I can reference for this is I have spoken with people with mental defect. I have spoken with people that have some delusions from substance abuse. They are difficult to understand. Would I say they're incapable of operating in normal society and life? Yes. However, competency is different from being able to operate in a day-to-day function of needing a guardian. It comes down to, can you make decisions? Do you know what's going on? Do you have awareness of your situation? Now, the comments Mr. Fejerang makes, I'm not certain he doesn't know what's going on. He knows there's a judge. He knows he's in court. He talks about fighting. He knows he hit someone. Now,
What about the fact that he confused the victim with his defense counsel at the time of sentencing?
that one, and that even leads into what he was trying to talk about. And that's a potential interpretation of what he meant. I don't know if he meant that he was just at the prison and Michael Brown visited him. And I read through that section several times, and I'm not sure what he was referring to. And that is concerning. But that also leads to, was he himself confused, or is there a communication issue? And that the communication issue is a problem insofar as it prevents him from communicating with counsel and representing his interests. And in that capacity, I think he had more trouble at sentencing than at trial. I think at trial, his statements, while still hard to follow, are more relevant to the proceedings. I think at sentencing, and even at trial, I think when he raises the criminal thing and the drug thing, I viewed that as more a request for leniency and mitigation because he has a problem and he needs help. He needs support. Also, something I would have expected to see at sentencing, but at sentencing, he's talking more about almost justifying fighting and just events that happened. And in there, we also see, there's Bible references. I think he says Michael Brown is Balthazar, and I don't remember who Mr. Fejerang was. And there's cases like that where defendants have raised these kinds of delusions, and courts, after their review, and different scenarios, different records, not binding here, I'm not suggesting, but they have found that wasn't sufficient, that there's other factors involved that, the defendant did know. The fine hard line here is making sure that people who are like this and are potentially incompetent get hearings and are, we make sure, as opposed to, and
So if we were to find that at the time of sentencing, there was sufficient red flags such that the judge should have stayed sentencing and ordered a competency hearing. And so if that is the position, and so does it affect at the time of an appeal here in terms of any remand? Does that also require vacating the conviction, or do we or is it such that you can order a remand, vacate the sentencing, and he goes through a competency hearing, and then if he's found to be incompetent, then would then there need to be further proceedings that would affect the conviction? Or if there is the remedy such that if we find that he was incompetent at the time of sentencing, there was nothing different during the course of the trial that, you know, it affected the verdict, the conviction. The only issue in my mind, if we don't deal with the ineffective assistance, because the record on direct appeal is not sufficient for reasons that have already been stated here. We're saying that the judge had a duty to raise or not proceed because it violates someone's due process rights. But that duty wasn't apparent at the time of the trial. What's a fair remedy here?
Yes. When I would look to, and Guam statutes have incorporated this, but I like to say Blackstone. So I'm going to refer to Blackstone. It's going to, I think, depend on when the court determines that inkling of a bona fide doubt arose. And at that juncture is where proceedings would stop. So if we say it's at sentencing, the sentencing, you go back and you need to have a competency hearing. Assuming Mr. Fejerang still appears to be under the same issue, but for ease, I could say you just do a competency hearing. And then based on that, if Mr. Fejerang were found incompetent, I believe treatment could be provided. That would be.
But if we analyze it in terms of the plain error, and we, number one, follow Ninth Circuit, it's a structural error. That, I think, would lead to the vacation of the conviction. If we go through elements 3 and 4, and was his substantial rights affected? Does it affect the integrity of the judicial process and exercise our discretionary authority? Then that should also affect the verdict.
I think my response on that would be, I think if we're looking at the conviction being reversed, if we're looking at a structural error of just due process because there was a bona fide issue, should have gotten competency, didn't. And if you believe that happened at the trial, during trial, you would reverse and go back to trial after competency hearing to make sure he can stand trial. If that bona fide issue isn't there, then there was no reasonable reason to give him competency, and he was competent to stand trial, speak in his defense, proceed on to sentencing, where if the bona fide issue raises then how can he speak in his defense as to mitigation at sentencing? So if you find that the bona fide issue arose at sentencing, I think that precludes it existing at the trial, because otherwise it would have existed at trial as well. And if it goes back to then, and here's the thing, even if you can go back to pleading when he waived jury trial, if there's a basis to find that, then you'd start there and say, okay, start over from pleading, after competency is restored, and say, do you really want to waive your jury trial? But those points are all based on, if you're looking at structurally a due process violation, and even if I think you're looking at it from competency itself, I think you're still using the same benchmark of when does the bona fide concern arise that would raise this kind of due process requirement for competency.
Doesn't it go back to the beginning? Because if he wasn't competent, he couldn't assist his counsel in his defense from day one. Well, and this is part of the difficulty of the case we have now, is determining, well, one, if he was incompetent, because we are talking about appearance of this, but when he became incompetent like that, because it's not just the existence of delusional speech, it's the incompetency to know what's going on, to understand, to participate, and based on the record,
there's just not enough, I mean, to go back and I don't think there's enough to go back and reasonably say, I mean, what I would, I wouldn't reasonably say that, yeah, we can say he was incompetent at arraignment.
I mean, I think that she concedes that we can't determine whether he was competent or not
Yes.
competent. I think it's just a question of whether there were enough red flags for the judge to have sua sponte ordered a competency hearing.
Correct. And that's the people's position as well. And that's the difficult issue we're leaving to this court is where is the line? What does raise, I mean, is this sufficient for bona fide? And there's facts on the record that can be looked at. There's also absence of things that have happened. I.e., as I stated before, no sign of confusion, aggravation, disruption. Now that could be if he was incompetent, just going along with it. But even if we look at the PSR report, they say, well, at some point, Mr. Fejerang was agitated during an interview they had with him. So it doesn't just seem like a docile man. But the people rely on their brief. We've set forth the standards. We would concede the standard of review issue. I think it's a good point that's been raised that that abuse of discretion comes after an evaluation and is based on the court's determination at that point, not a failure to look at a bona fide issue that requires competency hearing. And with all that, the people have really covered all the issues they had in this, I think, a difficult case. If there's no further questions, we would rest our argument.
Thank you, Mr. Tennyson.
Thank
Ms.
you, Your
Keith,
Honor.
you have 7.5 minutes.
Thank you. I just want to briefly mention, I believe that the Attorney General's argument is that something has to first happen to alert the court to a competence issue. And then he mentioned there was a balancing test. I want to disagree and say, when something happens that should first alert the court to an issue, there's no balancing test after that. It just stops. The other thing is, similar to his brief, the Attorney General argues, it's almost like quantity, not quality. And I'm going to just read a couple of the sentences that Mr. Fejerang said at trial. He said to the judge, "And I don't see there's no flood in this prison with the federal courts because as I walk to a Agania, only alpha block that has been used. And Judge Francis Tadinko Gatewood, I really feel for her." And he also said, "My intentions is only to flood the prison that everybody here can exercise their mind to the 9 GCA or federal laws that I can bring. I can bring only if granted the opportunity." While my opponent claims there's no frustration, and he was by all observations a very polite man, he was completely confused. I contend that the confusion arose at trial, not at sentencing, because the sentences I just read right there, I think you need to just stop because those things don't make sense. I don't think it's a sophisticated argument. I think the Attorney General suggests that you can make sense of Mr. Fejerang's statements, but I really believe that this strains credibility to think that he knows what he's talking about. He's a very polite young man, but these comments don't track. While Mr. Tennyson claims that not just, you don't rest on just one element, and he cites many cases that it's not just one thing that throws the proceedings into doubt. You got to have a lot of things that throw the proceedings into doubt. But you have to look at scale in this case. There was just there's a short record, short time frame. And I think in light of the brief brevity of this case, these comments suffice as throwing that doubt in. And once that doubt is there, I think I think it's more urgent for the court to stop proceedings. And while I have conceded that if he was only, if he demonstrated his incompetency only at sentencing, his conviction would stand, I cannot concede that that's even a possibility because of the kind of things he said to the judge. He was just simply, I think it strains credibility, and I think that the comments speak for themselves. With that, I believe Mr. Fejerang's trial was fundamentally unfair and that he should be entitled to new proceedings. I urge this court to vacate Mr. Fejerang's conviction and return the case to the trial court for suitable proceedings. Unless the court has questions, I will submit.
I have one brief question.
Yes.
If this goes back to the trial level, do you think, I forget if it was public defender, alternative public
Yes,
defender,
public defender.
should continue to represent him? Or should we order the trial court to appoint new counsel?
Oh, I think that the public defender can continue to represent him. I think, yeah, this particular, I don't have an argument with this public defender. And in fact, I think public defender in the court should be saluted for moving this trial so quickly. But I think it just moved a little too quickly. I think public defender could be appointed.
All right, thank you, Ms. Keith.
Thank
Thank you, Mr. Tennyson. The court will take the matter under advisement, will issue a written opinion, and will now stand adjourned.